I appear for the 8th respondent.
Yes.
And also call brief only for the 7th respondent.
Thank you.
Your Honor, this is the Lord Chair, the 91st respondent.
Thank you, our Chair. Who is next? Any other counsel?
Please, my Lord. My name is Waiting. I do appear for the second that respondent. Together with Faith Mutua.
All right, thank you. Is there any council or party who has not introduced himself or herself?
Lordship in the Event Commission.
Please give a microphone, council, if you don't mind.
Your Lordship in the Event Commission. Allow me to introduce World Brief for Mr. Evans Ogada, who is unable to, his audio is not working, but he's logged in. He appears for the 11th and 12th restaurants in all the applications.
All right. Thank you very much.
Very quick,
Yes.
yes. I appear for Human Rights Commission, which is the attention to
Okay. I think we are done with introductions. We are gathered here this morning for purposes of giving directions in this form applications. But before the floor proceeds to give directions in these matters, there is an issue that I wish to bring to Council's attention and that of the parties. Of the judiciary to advise him and the Judicial Service Commission on the response to the proposals in the Building Bridges Initiative, the BBI, regarding the judiciary. Two judges of this court, the Honorable Lady Justice Anna Okwengu and the Honorable Mr. Justice Katorima Ntuinoti, were members of that committee. On the advice of the committee, the Chief Justice and the Judicial Service Commission recommended that the structure and functions of the Ombudsman as proposed in the BBI report and the Constitution of Kenya Amendment Bill be abandoned and instead the Judiciary Ombudsman be appointed by the Judicial Service Commission. The purpose of making this disclosure is to notify you and all the parties accordingly, so that if any party is uncomfortable with the participation of the two judges in these proceedings for the aforesaid reason, may so indicate at this early stage before the bench that will ultimately hear the appeals is constituted. I hope that issue is clear. We do not want a situation where after the bench that will hear the appeals is constituted, we begin to get applications for recusals. We would rather, if there is any, be raised at the earliest opportunity so that I am duly informed before I proceed to constitute that bench. And you must also know that we are very few in the court currently. Some judges are on official leave, and we are not that many that are available to hear these appeals as and when the dates are set. So senior counsel and council president and parties, I hope I have been understood, and if there is any objection, it will be raised at the earliest opportunity, even now. But if not, we'll proceed now to deal with the other issues that brought us here, that is to give directions. Okay, I take it that there isn't, and thank you. Or are you waiting to take instructions, perhaps? I have senior counsel who are very quiet. They are not telling me yes or no.
My Lord, for our part, the Electoral Commission, on my own behalf and that of my learned colleague,
Yes.
we have no objection.
Thank you, senior counsel.
We want to make that a record. At an appropriate time, we will be making the argument that that is how the matter in the court will go.
Thank you.
On behalf of the Attorney General and the Solicitor General who is with me here, we should admit that we have no objection whatsoever. And we shall equally raise the issue in an understand. Senior Counsel, please have it.
Thank you, senior counsel.
On our part, ladies, we have no objection. In any event, they were doing that and we know the
Thank you, senior counsel.
My Lord and ladies, on behalf of the Building Bridges Initiative, sorry, the Honorable Right Honorable Ginger, we have no objection. John, my senior colleague, in stating that, this is one of the issues we will deal with in respect to the High Court.
Thank you, senior counsel.
My ladies and my lord, I believe I can speak for most of the petitioners, if not all, before the High Court, who constitute the respondents. We do not have an objection to Justices Lady Justice Anna Okwebu and Mr. Justice Rima presiding in such a bench that will be constituted here this night.
Thank you, President LSK.
My Lord, perhaps I can speak on behalf of the junior counsel. I confirm that we do have no objection to either of the two judges that are participating in the matter. In the event that issue is not an issue in the High Court, and when the two judges were answering the matter, they were not actually in the decision of the judge.
Thank you, counsel. All right. Thank you very much. Now,
Lord Mayor,
yes.
but I have a preliminary point here, my lord, concerning the remarks made by a prosecutor.
Can you please move next to microphone? Yes.
My lord, am I audible now?
Just check whether it's on.
It's on.
Okay. Thank you.
My lord, with your kind permission and with the indulgence of my colleague, I seek a directions on remarks made by a party to these proceedings using the high office of a state officer, and in a manner, my lord, that will throw whatever we are about to do before you into disrepute and would undermine the public confidence in this court to deal fairly with the matters before it. My Lord, speaking at a national event, the Madaraka Day celebration, His Excellency the President, my senior counsel, Mr. Gatonyo's client, made remarks, my Lord, which would be concerning to all other litigants before this court. And so, my Lord, we seek your permission to formally bring those remarks before the court so that they can be pardoned, because they amount to contempt of court, my Lord. And contempt is jurisdictional it should be purged first before the court can go on to make other arguments.
Thank you, counsel. Can we deal with that just as we finish with the directions? I hear what you've said, and we will come to it at an appropriate time. Thank you.
Tonight on KBC Channel 1.
We got the Congo long just like the Amazon. Split big like a cylinder, man up beat like gun.
That's my word. Time for me do it now. I hope you heard, girl.
Solo getting I found true love and it feels like freedom. Oh my God.
I'll give you all you want. Don't even have to ask, what will you give me in return?
Give you all my love, my love, my love, my love, my love. Give you.
I feel like I'm failing in what I was put on this earth to do. I want to make a difference, like you did.
You can never underestimate the power of grace.
Listen, Donald, I'm sick about the man's family. I was called to minister to people. That's what Mac's doing in my life, Deborah. Showing me what my heart really is.
So you thought you
just answer me this, Sam. What is there to believe in, man?
You know we in this together, man.
You do, so we think that you're good.
I promise to pray for you every day, ask your forgiveness, grant you the same, and be your friend always. That is the grace card.
The Grace Card. Next on.
Bye.
Okay.
Tiff. What is it, Eric?
Is that Tiff?
At least find out who Glenn is working with.
Ndamsaka alafu nitakushow.
Kama unataka uzuri, usichukue pesa ya huyo mama. Utaenda jela.
Unataka kumwaga uga.
What do you think is going to happen once you solve your father's mystery?
Let's wait and see.
If I go down for anything whatsoever, you better believe I'm taking Joel and Chris with me.
I can't take this anymore. I'm done.
Cheki, mimi naona tuishie. Wewe zidi.
So this is your game plan?
Next on.
Ndai pesa ngapi? Mahamri 10. Sijauliza mahamri ngapi, ngauliza pesa ngapi.
Lakini sasa ngoja niwaambie kitu kimoja. Wahenga wanasemaje? Asifuzwa na wazazi wake, ufuzwa na dunia.
Ndio hivyo.
Ndio mambo mnayoyaona jamaa. Anakula kama mchwa.
Sanduku? Sanduku lenyewe li wapi?
That a blanket challenge to our jurisdiction would not be in the public interest. Subject to that kind of order being obtained from your court, my lords, we would be very happy to go directly to the and we agree with my lords that it would be double work to hear the applications and then hear the appeal. And for us, time is of the essence. The electoral calendar is sticky. And every day is expensive for us because we need to procure materials, we need to recruit staff, and so on and so forth. So that is what we do.
Thank you, Senior Counsel.
Excuse me, please.
And there are a number of
Senior Counsel,
yes, ma'am.
what interim orders do you have in mind? Because we just talked of some interim orders.
The interim orders we obtained from the High Court, I will allow my learned friend Vincent to state that.
Thank you very much, Malay, for that question. So, on behalf of the IEC, the interim order that we obtained from the Superior Court were in relation to the question of quorum. One of the findings from the judgment from the Superior Court touched on the quorum of the IEC in the discharge of its functions. And Malay, the concern that we have in relation to that is that then it may permeate into other concerns for the other constitutional mandates of the Commission, including the by-election, some of which will be coming out so that between this time now, in Kiara and Muguga.
So you're, in other words, talking about interim orders that will allow the IBC in the interim period to continue discharging its statutory and administrative functions.
Yes, sir.
All right. Can we have views from other council regarding whether to hear the applications or the appeals?
No, we are in 151 and 153, and the appeal, and indeed the appeal by the respondents in the Superior Court are all in fact. And in the normal practice of this court, unless there is a compelling reason, once the appeal is filed, it is normally inclined to grant another to maintain the status quo so that neither party is prejudice pending then. But the order that comments itself as our practice that we proceed with this appeal against the country's waiting for the determination of the way forward. And unless this appeal is determined, I do think that the whole process going towards the next election is frozen. And therefore, we would be agreeable to agree for a quick timetable to proceed and have the appeal harder and coming. And in our estimation, I was thinking that 4 days, 2 equally divided on each side would be sufficient to cause that.
Sorry, 4 days for
both sides.
For both sides. Okay. Okay, and while you're on your feet, on the basis of what you're saying, although we will come to the issue of time, let's first of all, it's okay. We will deal with the issue of how much time you will require to do your preparations. I'll request you to either address the court now or later on after we've heard the views of other councils.
I think it's better to hear the views of the other council. I've been given an indication.
That's fine. That's fine. Thank you.
Please, my lord.
Yes.
We share the same view, my lord, that all the appellants have been filed their appeals.
Yes.
And then those appeals being ready for hearing, it would save a lot of judicial time if we could abandon the application and move on to the hearing of the substantive appeals as soon as possible. And generally among council, my lord, disagreed that we would cooperate with the court to expedite the hearing of the appeals.
Thank you.
Ladies, time is really of the essence, and I agree with my colleagues who have spoken before me. The only point that I wish the court to make a little clearer before we can make a decision whether to abandon or withdraw the application, or compromise the application, is what kind of timeline if the court would indicate when the appeal is likely to be had, that would make it easier for us to make that decision.
Thank you, Senior Counsel. And we can give that indication right away. Depending on the amount of time you require to put in your respective submissions and replies, if say, for example, the appellants were to say they need the next 7 days or 10 days. The respondents to put in their replies 7 days thereafter. As soon as that time is spent, on the 16th, 17th day or immediately thereafter, the court would be in a position to set aside the 4 days. That has been suggested, for example, or if you say 3 or if you say 5, that is the indication that we are giving as a court, right? So that even though the court diary is very full, but the applications and the having been certified as urgent, and I believe the appeals are also equally urgent, we may have to put aside other matters to fast track this appeal. I don't know whether that is clear. Senior Counsel.
I think a lot of comfort to the Lord, so I think we should go ahead and get it rather than taking time on the application.
Thank you.
Just to add on what the Honorable President has said, it is not that we are favoring this proceeding. It is something we have done in the past, because each case depends on its own circumstances. We are in control of the diary. Depending on the peculiar circumstances in each case, we are able to reorganize ourselves and readjust and move forward.
Right. Thank you, my sister. Is there any other view or the rest of the council in the room, you are satisfied with what the senior counsel who have addressed the court have said?
You know, yes. My ladies and my lord, our clients, especially the respondents, may say, you guys never say anything in court. I believe for the respondents.
Can you please pass on microphone to the President of the State?
My ladies and my lord, I believe most, if not all, the respondents are of the same view proposed by the court and acceded to by the senior counsel, that we hear their appeals instead of their applications, unless there is anybody with a contrary view.
Thank you, Mr. Avi. Yes?
The only concern I would have is on the IBC's request regarding a stay touching on the...
sorry, just for record, remind your name again?
Morara Omoke.
Omoke, yes.
And on that issue of quorum, it is a very important issue that it will become contentious.
You need to speak up. Yes.
It will become contentious if that, if any kind of stay was granted in that regard. Our position is that there is a process ongoing for the purposes of filling in the positions that are vacant for the IEBC. It's almost coming to an end. And therefore, there could be no need to have a stay. But if that particular point is contentious, then I would go for having a hearing of that particular issue.
I see. So, you are happy with the appeals being given expedited hearing dates, but you will have an issue to say with regard to the intended application by IBC to get some interim orders to maintain status quo.
Yes, Your Worship.
Okay, we can deal with that shortly.
Well, my Lord, if I may, perhaps it would have been good for IBC to also disclose that they have another application pending in the High Court, touching on the extension of stay. We have already been given directions in respect to that application. We have filed our response to the respective responses. As a matter of fact, I think we have a mission tomorrow before the High Court. So I think then it would amount to forum shopping for them to appear to grant the High Court at the same time to the Court of Appeal seeking at the same orders. So in our view, we'd rather give that to the High Court because we have proceeded. We have covered a lot of ground with respect to that aspect.
All right. So the interim orders granted by the High Court are for a limited period of time?
Yes, you may know the interim orders that we obtained from the High Court lapsed. Then we approached the High Court for an extension of those orders. The High Court had the matter by way of written submissions, and a ruling is pending. Yes, I think my learned friend corrects me that they have given directions on how to dispose of that matter. But I do not believe that we are not entitled to be here in the 5.2D. And it's in the context of the 5.2D that we were saying we are willing to compromise it if we are able to have a consensus on hearing of their views. So we are not shopping for a forum. We were already here legitimately before this one. Now that I'm on my feet and with your permission, my Lord did raise the question whether we should file submissions within 7 days or 10 days. For my colleague and I, we suggest that 7 days is more than appropriate. I agree with my learned friend, Senator James Orengo here, that all of us are fighting against fire, and every day matters. 7 days would be enough.
All right.
My Lord, if I may address the court at this junction, I'm aware that in addition to the 4 appeals that are seeking to wholly set aside the judgment of the High Court, there are 2 other notices of appeal that have been filed in the High Court. One is by Morara Omoke, which is an appeal that seeks to affirm part of what has been determined in the High Court, and also seek additional orders from this court. And one is by myself on behalf of the proposed 75th respondent. These 2 partial appeals, part of the judgment, have not yet been converted into records of appeal. And under the rules of this court, Rule 74 and 77, those appellants were entitled to file their appeals. And so I'll be requesting the court to give directions. One, to possibly consolidate the existing 4 appeals and to give clear directions as to the new numbering of the parties, so that the appeals are dealt with as one matter. This is in accordance with a long-standing practice of this court, and it will then allow all the parties who are supporting or opposing the judgment of the High Court to be heard jointly in one proceeding. And number 2,
yes,
that the court give a limited time, and we would request until Friday of this week for those other appellants who have filed notices of appeal and who are still within time to file memoranda of appeal and be exempted from the requirement to file substantive records of appeal. This again is something for which there is precedent, and if given an opportunity, I can quote a precedent from the Supreme Court where this has been done in cases where you really have records of appeal filed by some parties and other appellants are yet to file records of appeal. It is in the spirit of Article 159 of the Constitution not to require additional parties to file the very same record if the core of their appeal is the memorandum of appeal. If those 2 directions are given, we would be happy to comply with the timelines to be issued by the court, so that we are heard in accordance with the rights that is found in the Court of Appeal rules.
All right, thank you. And just before that, May I know from council whether you are, I've seen an application by Mr. Kanjama for joinder. Is there anyone who is opposed to that application to Mr. Kanjama coming in? I believe you have filed a notice of appeal, isn't it?
My Lord, if I may, I quickly respond on that one.
Yes.
The application for joinder was in respect of the 5-2B application.
Okay.
The moment the 5-2B applications are abandoned,
yes, we
the
will.
application for joinder
will become spent.
Will become otious.
Okay.
However, in regard to the substantive appeals, we do not need to make an application for joinder.
As long as you filed a notice.
Yes, because
that is fine. Thank you.
And I know there's one third point I was forgetting to mention. Also under the Court of Appeal rules, there is a provision for other respondents to file a notice of cross appeal the moment they are served with the record of appeal. So that indeed some of the other respondents here may still want to cross appeal. And I will be requesting that as we file a memorandum of appeal, any respondents who would like to file notices of cross appeal be given the same time, so that all the, we could call them basic pleadings in the Court of Appeal are on record before the submissions are granted, filed.
All right. Thank you. Thank you very much. Lastly, I saw Dr. Kiankolu.
Yes, my Lord, on behalf of Moraro Moka, we are taking the court permits us so that we are not seen to be slowing the process when everyone else wanted to move fast. We are happy to treat, if you allow us to treat our notice of appeal and the notice of cross appeal, so that then there will be no need for us to refile the same voluminous documents that have already been filed, the record of appeal. So in that file favor in the court.
Please come again to treat what?
The notice of appeal already filed, and the notice of cross appeal, so that when we go to the main appeal, the issues would have wanted to be addressed as partial appeal can be addressed by that notice of cross appeal. Of course, we are happy to file a notice of cross appeal on this, only that I think will be increasing the paperwork again. But for no really good cause, I think it's a matter where we can be as flexible and as accommodating as the circumstances require. Now, before my
Tonight on KBC Channel 1.
If your daughter won't cooperate, then you're being useless. So you do what you have to do, but I want her to have enough nutrition and to get stronger. Is that clear?
If you had told me that you already had a partner, everything about us would have been completely different, Dad.
Believe me, I had tried. Honestly.
Look, Uncle, the sad thing is, well, your son is a criminal and he must pay for what he did. I couldn't believe he came to rob us. You know what I mean. He took advantage of our trust in you, so he deserves it.
I'm going to see a lawyer, Maya. After that terrible thing that you did,
You have said
I'm going to
enough.
sue for custody. And I won't give her to you ever again. And you're not sending her to America. You hear me?
Next on
Sasa poa sana. Umekaa muda bila kuja hapa.
Si unajua last time mlinitengeneza nywele vibaya sana.
Oh, na vile tumetengeneza vizuri. Kwani siku hizi ni pesa una ama ni nini? Tangu nikushuke. Chau.
Pesa ama shughuli.
Pita napiga. Ngoja kwanza niongee.
Na haraka kidogo tafadhali.
Una haraka?
Unaenda wapi?
Msema wewe ni nini unafanyia pesa yako wewe? Nini? Wewe lama. Na bado unaendelea kucheka. Ni nini? Mse unafanya nika umetoka kunyolewa na kiposho mil mzee. Wacha mchana.
Huo ni ungwana.
authorizing the IBC to start preparations for the so-called referendum and whatnot. It can be an order allowing them to do all other things except anything that relates to the controversy before this court. Thank you, my lord.
Thank you. And before you say, now, Dr. Tangor, you are saying the court can treat your notices of appeal as cross appeal.
If the alternative we can allow to file a notice of cross appeal.
Yeah, because a notice is just a notice of appeal.
Yes,
it doesn't raise the issues that you intended to agitate on appeal. So I think putting in a cross appeal will be the ideal position.
Okay.
And we should be able to do that within any time given by the court, maybe it's as early as tomorrow.
Okay.
Maybe just for clarification, have the proceedings in the lower court been prepared so that you are ready to prepare the the record of appeal? I think that is important as we work on the timelines.
My lord, my lady, if I may just take one moment to perhaps make a comment in relation to that concern. On behalf of the IBC, my lady, we have actually filed the complete record, and I believe all the other parties have filed the record of the case.
All right. Thank you.
My lord, with your permission, there is a concern, and perhaps this will give us a proper compromise in relation to the orders that the IBC is seeking. When the judgment of the Superior Court was delivered, we made an oral application. We expressed the same concerns that we expressed before you. And the court then exercised its authority to give us the orders in those terms that my learned friend Sambolo is talking about. So that the orders were limited to questions around, all the other functions other than anything touching on the referendum.
Correct.
Yes, and just the other question that perhaps would be important to mention, the application that we filed before the Superior Court was purely for extension of the orders. And what we did, my lord, is we were then just bringing to the attention of the Superior Court the fact that the appeal that we filed and the application in 85 to be had been certified urgent, and that the court had been properly seized of the matter. But given the manner in which this court then proceeds, it was not possible to approach the court for any interim orders, which were then lapsing. They were just given for 14 days, and those 14 days were, I think, lapsing on Thursday of last week. So it is purely for the extension. If we were to say then we go to that court, then it will put us in a situation where every other time we would then keep extending those orders. I think what would be, in my view, decent to do is if we could stick with the proposal that has been given by my learned friend, that we have an order that will permit the IEBC to continue the discharge of its other functions, not touching on the referendum. As we hear the appeal, we would be happy to work with that compromise.
All right. Thank you. Yes.
It's quite clear that the court is handling this matter with a sense of urgency. And that's the way things should be done. But I would argue that if you make it better to avoid giving in the state, let us see what the state with us. Let us proceed with the certified decision that remain appeal by this court of appeal.
Even in respect of the IBC continue with the administrative and statutory functions other than matters relating to the live issues in court?
Yeah, I agree that my expectation is that our politics is in the state. But let us handle the matter with a sense of urgency and proceed in the main appeal so that they have possible.
My Lord, the proposal made by Dr. Camino would not be justified as this was not part of what was litigated by the parties in the lower court. The ability of IBC to conduct ordinary, routine administrative work was never litigated in the lower court.
All right, thank you. I want us to... I agree. Yes, Senior Counsel? Yes.
The entire matter is very sensitive to everybody, but I use that word. It's very sensitive to the entire nation.
Counsel, you need to raise your voice.
Yeah, I don't know. Can you be given a microphone?
Oh, yes. Madam, the entire matter, if I may use this word, is very sensitive to the entire nation. And it's proper that the court is not misunderstood in any way by granting it. Let us just proceed and to have the appeals disposed of. And I believe that we can do so before the end of the month to have disposed of it.
But senior counsel, without making any determination, if the court were to allow some kind of interim orders with respect to IBC, but preserving the sanctity of the proceedings so that IBC does not touch on anything to do with the matters in controversy, but it can continue to function insofar as the arrangements for the pending by-elections are concerned, and whatever other duties it's doing, anything that is not touching on the merits or otherwise of the appeal. Would you be prejudiced, your client be prejudiced in any way?
This word perception, this is perception is troubling my own mind. This is perception to the rest of the Kenyans and so on.
But perception is, yes, important, but it's neither here nor there. It's difficult to really judge the correct view of public perception. But okay, we'll deal with that. Thank you, counsel. Sorry, just hold on. Sorry, Mr. President. Yes, that's true. Yes?
My ladies and my lord, with your very kind permission, the order which the IBC takes umbrage with in the judgment is order number 10, the effect of which was to state that the IBC did not have quorum to prepare for the referendum, to verify signatures in support of the BBI bill. It's quite unfortunate that by the time the judges of the High Court completed their deliberations, it was almost midnight. That is when they issued that order. But I believe the order may have been issued without taking into account a previous decision by Justice Okwan to the effect that the full quorum of the IBC is not required for purposes of conducting the day-to-day activities of the Secretariat or for purposes of preparing by-elections. Now, if we were to take into account that fact, it will become manifest that the anxiety on the part of my two learned colleagues is really not imminent. And with that, then we may clear the deck so that we go and proceed on the other germane issues.
All right, thank you. We hear you. We will make some directions. Thank you. Now, Mr. Dudley, yes?
Yes, sir. On the question of timing.
Sorry?
May I speak on the question of timing?
Yes, actually I was coming to that, but thank you. On the issue of time, so that you speak, I heard from the senior counsel that 7 days would be sufficient to put in your respective submissions. If that is for the appellants, and taking 7 days also for the respondents, would there be a need for a limited period like 2 days to make a response to that? Yes. 2 days or 3 days? 2 days. So 7, then 7 and 2. 3. 7, 7, 3. Okay. 7, 7, 3. That's about 14 plus 3, 17 days. Okay. That is okay. The next, yeah.
The question of time, my colleagues and the court, I think, are a little bit too optimistic, my lord.
Yes.
We've been served with 3,000 pages by the Attorney General, and my good friend Mr. Coleman has also served another 3,000 pages. Mr. Gumbo as well. Those are about 90,000 pages, my lord. And we are entitled file court appeal and ground of affirmation. So that time we should first of all set aside, and we requesting for some 21 days. This is a 321-page judgment law, and it's one of the most significant issues that this court is ever seen. So we can expedite it, yes, but let us not push it at reckless speed, which does injustice instead of doing justice to the man.
So what's your suggestion, counsel?
I'm requesting for 21 days for the respondent to look at the appeal and raise court appeal and also seek to affirm the judgment. Then the parties can have maybe another 21 days for each side to file submission, so that we just do justice to the man. What is your thoughts? Thank you. And on the issue of Mr. Kanjab, which is still hanging around, Rule 75 is why anyone can file a notice of appeal, but it does not grant direct access to a matter. Because we need to know what step Mr. Kanjab needs to raise the matter. And so we request the court to direct him to make a formal application, so that even if we consent to it, we know what we are.
All right. Now, before you sit down, counsel, don't you think 21 days would be too long a time? Even in the presidential election petition, we hardly have that kind of time being granted. I am sure from the date this judgment was delivered, even before you were served with the record of appeal, you were interacting with the issues, and therefore you are able to work within a shorter period of time. Perhaps 10, but 21 seems inordinately too long.
What could we do with 14? Half the people that we ordinarily have in system, instead of the fact that they won't give us.
Mr. Mwangi, then Mr. Dr. Tiangoli.
My Lord, even in the High Court, that is when we were primarily developing the argument, the timeline that was given was 14 days. It is only us who are allowed extra time because our response to the petitions spread across all the petitions. But all the parties had to do 14 days, and that was in the primary argument. As your Lordship has said, everybody has interacted with these documents. There may be many, but nobody is seeing them for the first time. And we are not bringing any primary new arguments before your Lordships. So 7 days, and I think we would be the ones who would be more worried about the timeline, because it is us who's presenting the case. And we are saying that we do not think we'll be introducing anything much new, we'll just be renewing the arguments that were there in the High Court. So 7 days is perfect for them.
Maybe the appellants, you have already done what you needed to do, like filing the appeals, and you have already prepared everything. Could it be that the respondents require just a little bit more time to look at the papers that you have filed, like 10 days or 14 days? I take it that, for example, senior counsel, have you already filed your appeal?
My Lord, we have filed our appeal.
Yes.
And it has to be remembered that this was a record of the High Court in which all parties participated, and they had all the documents. And the appeals are the same record for each of the appeals, so they are not separate records for each of the appeals, thereby making 9,000 pages.
So indeed what you will be doing is just to prepare the submissions?
Yes, all we are doing is preparing for submission on a case where each party participated in the High Court and had access to all documents which have been filed before.
All right. Dr. Diankolo?
So if we begin from that, my Lord, then we proceed on the basis that in presidential elections, which are participating, we are given 14 days to prepare the petition and have the case heard and determined. And parties are able to do it. When I did a presidential election, I had 12,000 pages, 9,000 of which were rejected.
All right, thank you. Dr. Diankolo?
My Lord, I think the issue that is not coming out clearly is the issue of fairness and indemnity. this judgment being appealed was issued on the 13th May. The respondents took us only 2 days ago to manage to assemble their records of appeal and serve them. We have already had about 17, 18 days. So as we speak, they are hesitant because it is them who are minded to appeal, and therefore it is them who have the incentive. Up to that point, the appeal was being filed. So it is not worth too much to suggest that if only for purposes of evenness. If then, with all the interest they have had in seeing this DPA go through, have taken about 20 days to file this appeal, they have had a head start of 20 days. So when we ask for 21 days, it may sound initially like we just want to wind down the clock, but it's actually a matter of giving every party a fair, not necessarily a very generous, but a fair opportunity to examine all those documents and be able to make a reasoned position on their appeal. My Lord, even if we think it's just one record running 9,000 pages, and you give me 7 days or 14 days, you are suggesting I can read 1,000 pages more a day, and besides reading it, do the drafting, the legal research required, and what, it's just not humanly practical. And I appreciate, we agree without any reservation that this is extremely urgent, but it doesn't mean the requirement of fairness being sacrificed at the altar of expedition.
I hear you, Counsel, and we will take all those issues into consideration when we retire to give our directions in a little while.
My Lord, I just wanted to point out.
Yes.
Part of the record that we are talking about is a record of their own petitions and affidavits that they filed in the Superior Court. Part of that record is their own submissions. And you know, in the High Court we have more than 10 petitioners. Part of that record are their own submissions that they filed in the High Court. Part of that record are the authorities which they submitted to the High Court. So this emphasis on the length of the record is record which primarily was generated by the respondents. So they do not need really to go back and read that stuff. It's material that they're familiar with. We are trying to get a consensus, and that's why we are agreed to abandon or withdraw the application so that we can get this matter heard expeditiously. So, my Lord, I would plead that instead of going back and forth, that you give your directions. And even for us, filing of the appeal was delayed, not really, or not delayed, but it was filed when it was filed, because we were waiting for the documents and the decree. We could have filed it even within 7 days. But I think we got the decree on Monday. That's when we got it. Otherwise, we wanted to file last week.
All right. Thank you, Senior Counsel. We'll take those into consideration. I want to go to something else because we are not going to exhaust that issue now. We will be retiring to give appropriate directions, but we have heard the general drift of Counsel. I want to move into something else regarding the directions. Yes.
And I just want to get my learned friends here that the records of appeal are in form of soft copies, which can only be accessed by way of Google Drive. That means that even for the respondents, we must have internet throughout to do that. The capacity of our machines is also not that good. So then if the appellant can be directed to some hard copies to us, because that makes it work easy for us to even peruse through the records of appeal and try to find out whether they're complete and whether we need to put in any supplemental records of appeal. So I would ask them to supply us with hard copies. Their clients are well endowed in terms of resources, thanks to taxpayers' money. So we can have that so that
by the High Court. And even the email service threads that are there were set up by the High Court. There was no complaint then. All documents in these matters have all been served online. And it was agreed with the direction of the judges then that the Deputy Registrar of the High Court would set up that mode of service, and it was set up by the Deputy Registrar of the High Court. It is the same method that we have been using even since we came to the Court of Appeal.
Yes.
I would like to emphasize a word that I'm afraid is going to refer to spend.
Spend.
Fair.
Fairness.
Yes. My Lord, we have to be fair to the parties. I support wholly my friend, Mr. Darcy, and support my friend, Mr. Mudoli. Speaking on behalf of the Human Rights Commission, before Sharia, we have to be fair to the parties. Some aspects have just come in this month. They don't know what the whole matter is all about. So to suggest 14 days or 10 days, it will not be very fair. I would suggest to your Lordship, very respectfully, that 21 days would be very fair, so that everyone takes the picture. Otherwise, if we try to hurry up the whole thing, we may find that some people will be living in the courtroom feeling that they have not received a fair treatment. Let us be fair. 21 days is not too much. And the paperwork, from what I've seen, are giving us 21 days is fair and
Thank you, Senior Counsel. Mr. Kanjama, we will certainly consider all those views regarding time.
There was an issue that was raised relating to the intended appeal that we have filed a notice of appeal, and I wanted to address the court very briefly on that issue. Because, my Lord, what is happening is that under the rules of this court, there are 14 days after the judgment is issued to file a notice of intended appeal. That period expired on 27th of May. On 27th of May, there were 2 other notices of appeal that have not yet been converted into memoranda of appeal. Under the rules of this court, there's also 7 days after filing a notice of appeal to serve the other parties. That period expires tomorrow, on 3rd of June. Even though on behalf of the 75th proposed respondent, we have already served our notice of appeal. So the parties are deemed to know what it is we intend to appeal against. And that means that we have time from the time we served the notice of appeal to prepare our records of appeal. Under the rules of this court, we have 60 days. But we are saying, in order to expedite the process, if those appellants who've already filed records of appeal can serve us, who have not been served, and we can be exempted under Article 159 from having to prepare our own records of appeal, so that we only file memoranda of appeal.
Mr. Kanjama, we heard you on that, and it's recorded, and so I think...
So the last thing I wanted to say, my Lord, is that also under the rules of this court, when one receives a record of appeal, one is given time to peruse it, so that if there are incomplete sections, there are documents missing, you can file a supplementary record of appeal. So we think that in the timelines that the court provides, it should give the respondents as well an opportunity to confirm whether the records of appeal are complete and to file any supplementary record before the submissions can be filed. That is all.
Thank you very much. Thank you very much. We will give appropriate directions, and thank you for all the views that you have expressed on the issue. Now, on the length of the submissions that you are going to file, I want us to agree on that. Ordinarily, we say 12 pages, but I realize that is very limited for this kind of matter. Can we limit it to 20, 25 pages? Reasonable submissions. And then we cover that with the amount of time that we are going to allow each council to address the court to highlight the submissions if highlighting is deemed to be necessary, knowing that the amount of time that we are going to agree upon, if it's 20 minutes, if it's 30 minutes, even if you are a party is represented by 3 council or 2 council, you share the time amongst yourselves or between yourselves. So we want to hear your views on that, so that as we retire, we give comprehensive directions. Length, let's start with the length of the submissions.
No, the length of submissions, we were requesting 30 pages because on the part of the Attorney General, he's the only party who is dealing with almost all the issues which are being raised. And therefore, it will require quite substantial submissions.
On our part, my Lord, we require 20 to 25 pages.
Yes.
My Lord, IBC is happy with 20 to 25 pages.
Yes.
My Lord and my ladies, we require 30 pages. The reason being that the 2 appellants that we represent are affected by nearly all the issues that arose during the petition. We're in the almost exact position as the Attorney General, but I think we are a little bit more in every aspect of the case. So 30 pages.
All right, thank you.
My ladies and my lord, I think an average of 30 will do.
All right, thank you.
Most of the respondents, unless there is
thank you.
The only slight addition, my lord, is that as the respondents will be responding to 4 appeals, raising different issues, some of issues of course are shared, and therefore we may require maybe slightly more than the pages that each of the appellants will require. I will pray for that before the pages.
Sorry?
I will pray for that before the pages.
Okay.
On our part, my Lord, 30 pages will suffice for submissions. I also intend to make a small application to be allowed to adduce further evidence under Rule 29 of the Code of Appeal Rules to introduce the joint report of the National Assembly and Senate. But it is key to our petition, because one of the issues that the court will be asked to look at is whether we had a legal framework to conduct debates and referendum in the country. That report captures most of the sentiments. The reason why we were not able to produce that during the hearing in the High Court was that by the time we were hearing the petitions, the process at the National Assembly was still ongoing, and judgment was delivered after that report had been produced. So I do not think there will be any objections.
So it will be to introduce the what? The report?
Yes, the report by the Joint Committee of National Assembly and Senate. And the answer it is key to our petition and the appeal as well.
Okay. Thank you. That's all as far as time is concerned. We have had the range. We will give appropriate direction. And the issue of time, the time that we are going to allocate for making any necessary oral highlights. Senior Counsel, Mr. Roy?
I had suggested 4 days, each side to have 2 days.
And yes, but I want us to cap it in terms of minutes. We cannot have just 4 open days. Yes. We want to agree in substance so that even as you prepare your submissions and looking at the authorities,
we all have an idea that you will require so much time. We can limit you. We will have this timer adjusted accordingly.
And I do think that, one, on the respondent side, there are so many respondents, and I think allocating time will be a problem, as we have 4 parties. And I do think 3 hours, my lord.
Sorry?
3 hours for the appellant. Yeah.
For the appellants, all of them?
No, each of the appellants.
For submissions that have already been filed and exchanged?
My lord, I think the issues being dealt with here are very interesting principles. It will help the court for the appellants to clarify their submissions. I don't think they will be that understandable merely in writing.
At the risk of digressing, almost all of you have appeared before the Supreme Court in the presidential election petition. How much time are you having?
My lord, when I was given 3 hours.
Yes, the same for us.
3 hours.
3 hours.
And how many were you in total as counsel? Was it every counsel 3 hours, or it is only the ones who are playing very critical, rather representing the petitioners and the respondents?
No, it goes like this, my lord. When you're in the Supreme Court in a presidential petition, you get about 3 hours, and if you want another member of your team to address the court, you share that. So I believe Madam Fendi is suggesting strongly that each party gets 3 hours. If a party wants 2-3 advocates to talk, then that can be shared between the parties.
You know, thank you, I hear you, but you know, we have an average of 12 advocates or so.
Can I say something?
12 times 3 hours. You see how much time we're talking about? And then there's a replies and so on. We do not, we want to be fair, we want to dispose of this matter expeditiously, but we also want to do it in an orderly manner. We cannot sacrifice merit at the altar of expediency, no.
Yes.
Justification in maybe the appellant having a little more time, but for the respondents, really, I don't see any justification of saying they should also have the same time as the appellants, because they are not all dealing with all the issues.
Sorry, just hold on. There's something.
Now, in comparison with what goes on before the Supreme Court during the presidential elections, that is an original jurisdiction. They are dealing with raw material. Here, we already have a judgment. We already have the pleadings. And what our plea to you is, you are aggrieved variously. Now, assist us to understand what is it that you are not happy with or happy about the judgment of the High Court. The background information is there, the pleadings we have. If you can direct the major strength or focus on the core issues for us to understand, where did the High Court go wrong? Where did it injure you? And how do you want us now to bring out this? That is what we need. And speaking from my own experience is 30 pages, yes, and you are going to give 20 pages or 15 pages of that submission on the background. It doesn't assist us much. Identify the core issues, the grievances, and you are going to exchange documents from each other. What is it that so-and-so is raising? What is it that I need to chip in? So that your assistants understand the case and then address your concerns appropriately. That will assist us. 3 hours, it means now we are going to have to hold a hearing for almost 1 week or so, or you want us to be hearing anyway? We are open 24 hours and all that. Yeah. So assist us. Go straight to the core issues. It is not raw material. You already have it. And you can deal with the replies. If there are new issues coming, we are open because we want to do justice to the matter. Thank you, Mr. President.
Thank you, the lady. Mr. Harvey?
In any case, how much time did you take in the High Court?
Mama Lady, that's a germane question. In the High Court, the petitioners were each given 30 minutes. The respondents, because they were responding to many petitions, were given more. I think they were given an hour. Now, in this case, as the respondents will be responding to a total of 4 appeals, it therefore makes more sense.
It will be consolidated into one. So it will be...
Then still it will be issue-based. And my request is this. The respondents be given slightly more time than the appellants.
Which you suggest to be?
My suggestion was this. If the appellants can each be given an hour, then the respondents be given an hour and 30 minutes. Because I'm trying to compartmentalize this time within the 3 or 4 days that the court has proposed. If we have to do longer, then we can't even manage it within those 3 days.
All right. And realizing that some of the issues are so cross-cutting that once a particular appellant or respondent has addressed that issue, it may not require so much time to say the same thing.
Yes, that's true. For instance, like for us, we want the basic structure, thematic area, which if we have exhausted, then we need not have it repeated. Similarly, if Tuma here has addressed the issue of the quorum of the IBC, we need not address it. And I believe in the course of the oral submissions, the court will guide us accordingly, so that we don't fear of and repeat what another colleague has raised.
All right. So now, thank you.
You'd note that in the submissions you are restricting us to 30 pages. If you are not restricting us on the written submissions, then I would understand why we should get 1 hour. Unfortunately, looking at the judgment, there were nearly 23 declarations made by that court affecting our clients, 2 clients we represent, all those 23 declarations. And you are minimizing the length of the submissions. And there's the other very important issue that this matter, it's not just a matter for this court. The hearing of this petition will be done in the full glare of the public. People would want to understand why this court will make a particular decision. I will plead with you that this is a very unique case, it's a very special case, looking at the circumstances. And it is about our constitution. So I would plead with the court that if in an election petition, presidential, which is narrowed to the question of declaration of the seat following a presidential election, and you are given 3 hours for each party, and I've been in those petitions. In this particular appeal, or appeals, there were 9 petitions in the High Court, each seeking very unique declarations or decisions. And I don't think on behalf of my client or clients that an hour with 30 pages submissions would suffice doing justice to this case. And the public would also want to understand.
What would be your suggestion there for senior counsel?
I would go by the original suggestion that was made by senior counsel, Mr. Oraro, that you give us 4 days. And 4 days for this court to give to this very unique case would not be asking too much of your lordships. That out of those 4 days, you give 2 days to the appellants. And in the High Court, we had less time because each respondent had a petition before the High Court. We had to respond to all those petitions. And then the other 2 days you give to the respondents. That is how it is done in the presidential petitions. And it works very well. Between us, we can then share those 2 days and make sure that we make out our respective plans within those 2 days. I would really plead on this.
And what about if there are more respondents than the appellants, as it is actually here? So far, we have 4 appellants, and I think a number of, is it 10 or 15 respondents? Should it still be 2-2? Or because they are responding to more or less the same issues, you think that 2 days will still be sufficient? Senior counsel? No, just hold on.
Yes, because we are the ones prosecuting the appeals. They will be also responding to those appeals. So if they are given that, and normally this court would try to determine who are supporting the appeal or who is opposing. And you try to minimize their time if you're just opposing, and probably your participation in the High Court was just on one issue. There was a petitioner whose issue really was about the conduct of the president in respect of Chapter 6. It was basically one issue. And I think to that extent, we can be able to organize ourselves. For example, amongst the appellants, the IBC their role is not going to be as extensive as, for example, the Attorney General and ourselves. So between ourselves, we can organize ourselves in such a way that Mr. Raro probably can take 3 hours, and I probably can take 2 hours, depending on how we organize ourselves.
All right. As senior counsel, before you take your seat, in these COVID times, we are limiting the amount of time we are spending in a sitting like this. It is not comfortable wearing these things for 2, 3, 4, 6 hours. What about if we enlarged the length of your submissions and reduce on the time so that there is so much that is covered in writing? You are able to say, even stretch it to like 50 pages, and then you have like an hour and a half to basically highlight your well-written submissions, which are more exhaustive. I truly hear what you are saying. We need to do justice to this matter. But I think it is going to be very uncomfortable for all of us, whether we are sitting in this place or in a bigger space, as I will be saying in a little while, to spend 8 hours or 6 hours in a day putting on masks, being confined in a tent or in a courtroom like this. The presidential election petition and other matters have been done in what I may call COVID-free days, when the court can sit even up to from morning till evening at night. We really don't want to be in this kind of setup for too long a time. Yes, Mr. Kanjama, we'll come to you.
My Lord, if I may just refer to what Lady Justice Nambuye mentioned.
Yes.
And to say that I have been with senior counsel Rengo in the Supreme Court on an election appeal, not an original election matter. gubernatorial, the Supreme Court would typically give 1 hour maximum for submissions, even with very voluminous record of appeal and submissions filed by the parties. My Lord, I would like to add that because this is a constitutional matter, it's a matter in rem, interests of parties cannot be easily sliced and diced and categorized as either supporting or opposing. There is a lot of jurisprudence in the judgment, so that the idea of giving a block of time to appellants and a block of time to respondents does not respond appropriately to the fact that each appellant and respondent may have different views on the various matters. Thirdly, because of the rules of this court, even if a party in the High Court was focused on 1 or 2 points of argument, once the judgment has been issued, a party in the Court of Appeal, by filing a notice of cross-appeal or grounds of affirmation, will be interacting with the entire judgment. And each party may have different views. So that the appropriate direction should be focused on each party, whether appellant or respondent, receiving roughly proportionate time, because they each need to deal with the various issues according to the instructions of their respective clients. And I do support the suggestion by LSK President Nelson Harvey that each party should not have more than 1 hour. 1 hour roughly, they will determine how to use that time. That is all.
Hello, may I make a suggestion?
Yes.
I think I agree more with my President, Mr. Nelson Harvey, because the additional hour that we get in the main arguments, the respondents will claim it back in reply, so that in the interest of quality of answers, each party ends up having 1.5 hours. That's my suggestion.
All right, thank you. Any other view before we leave that issue? Dr. Tiangolu, then, oh, sorry, okay, you're on your feet. It's okay. Okay.
He says I can go ahead, my Lord.
Yes.
My Lord, while still on the issue of time, I think for me the considerations are as follows. Number one, this is arguably the most important litigation of our lifetimes. I've had comparisons with the presidential election petition, but if I had my senior Jimmy Orengo, this is about the constitution of Kenya, and it's about the posterity of Kenya. So in my view, although there is a genuine case for limiting the time, we shouldn't box ourselves into a corner that says it is 1 hour, it is 2 hours, as though what is at stake is the time and not the future of Kenya. So if the petitioners, or rather the appellants, want 3 hours, in my view, subject to an equality of arms, it is not too much to ask, in my view, for a case that is arguably the most important case of our lifetimes. The only thing I would suggest, my Lord, I think the reason we're having all this back and forth is we have boxed ourselves into the 3 or 4 days that the court gave as an indication. And I would urge the court to consider, is it possible to have, say, the 3 or 4 days in 1 week for the appellants and 3 or 4 days in the next week for the respondents, and then a direction that says those 3 or 4 days, the appellants must go and conference amongst themselves and know how to share the time, and in the other week, the 3 or 4 days, the respondents will conference amongst themselves and communicate to the court how they plan to share that time. I know, of course, this court is very stretched in terms of its human resources, but then again, it must be recognized that this is arguably the most important case that will ever be argued in our courts in our lifetime. As regards the physical space, again, I think it's a matter where we can be flexible. The state has no shortage of resources. I was just whispering to my senior, Paul Mwang here. We have even a facility here at KICC. We can set up a temporary court there they are gazetted specifically for this, then we can assuage some of these concerns about,
I will address that in a little while. Just limit yourself to the issue of the time, then I'll come to that.
So, my Lord, I was saying 3 or 4 hours that they request, they're just 4 appellants. To me, it's reasonable given the magnitude of what is at stake. It's about how Kenya is governed in the long term. The only right there is if you give them the 3 hours, then be mindful to give us as the respondents an equal amount of time that is fair, remembering we'll be responding to all of them, not necessarily to one of them, even if the cases are merged.
All right.
Can I say something, Madam?
Yes, Dr. Amino?
Yeah. Madam, I do appreciate what you're going to say about wearing masks. It's very uncomfortable. I find it very uncomfortable also. Because I would suggest that the best way out of this is to increase the number of pages that each party can submit to 20 pages or 30 pages, you could probably increase it even to 40, and then you are able to shorten the time you are directed in the court. Perhaps I may add, my Lord, it's not only Kenya that's interested in this judgment, but from what I've heard and seen and so on, the international community is very much interested in this case. They would like to see what you want to say and so on. So it's fair that each party is given enough time to be able to address the exclusively. And the only way we can get out of this problem with the COVID around 13 all of us is to allow us to put in more pages, probably 40 pages or even 50 pages, and then we can shorten the number of hours or the number of things we can address.
All right, thank you very much. We are going to...
With your kind permission.
Yes.
Yes, my name is Edgar Busiega. I just wish to go on record that I support what my colleagues have stated, particularly Doni, Yankolo, to the extent that parties ought not to be limited with time, such that time becomes the factor as opposed to the Constitution itself. Having said that, I'll urge the bench, when giving directions, to consider giving sufficient timelines of filing submissions, given that
of days that would be very amorphous and not capable of control, so that we have equal opportunity. We request for fixed time, and we suggest for 2 hours for the respondent and 1 hour and 30 minutes for the appellant. And then the 30 minutes can be compensated in response, perhaps.
All right, thank you. Okay, I want to deal with another issue. Unless it is very important, can you? Yes.
I believe it's important for them to also get probably equal time to those who have appeals, because in the cross appeal there could also be additional issues that they need to cover, therefore need equal time as the appellants.
Sorry, we forgot those who are on the screen. Mr. Olokir, there was, I don't know who else here. Was there anyone who is raising any issue? Are you hearing us?
Yes, Your Honor.
Okay.
Now, basically, I'm in support of the duties presented by the President Nelson Harvey and Charles Kanjama. We can have 1 hour maximum. As a compromise, I agree with the suggestion. We can probably add more pages for the written submissions, but we don't need to spend too much time on the oral highlighting. Thank you.
Anyone else? All right, thank you. Thank you. We have heard your views. We will take them into consideration as we give directions shortly. Talking about the issue of how the hearing is to be conducted and the space. One, there will be a bench of 7 judges to hear the appeal. And so you can see that we cannot sit 7 of us here and keep the COVID-19 protocols. So we need a bigger space. And arrangements have been made to pitch a tent within the court premises outside the Chief Justice's gardens with the permission of the Chief Justice, so that if we agree that we are going to do this matter, in that way where there is physical appearance, there will be adequate space for counsel and for judges. But we can also agree that we conduct the hearing virtually. I know from the correspondence that I've seen from most of you, and we know there are challenges when it comes to virtual hearing. Connectivity, sometimes Wi-Fi may not be working. We are not able to hear one another well. So I want to quickly hear your views on that before the court makes a final decision. Of course, today we are doing it in a dual manner where we are here, others are seated in a courtroom next to this courtroom, and there are many Kenyans who are following it from the comfort of their rooms because we have sent out a link. May I quickly hear your views regarding the mode of hearing that we should have? Senior Counsel, Mr. Oraro.
On the part of AG, we suggest that we have a physical hearing, and with the permission of the Chief Justice, we can proceed with the idea of having that hearing at 10,000.
On our part, physical hearing, and I think on the part of the premises proposed, we're quite happy with that space.
Okay.
We agree with what the senior counsel said. Physical, in-person hearing.
In-person hearing. Sorry? Sorry?
Virtual hearing and not hearing for
Okay.
My Lord, we are happy to associate ourselves with the sentiments of our colleagues.
Okay, in-person hearing, yes. Yeah.
My Lord, we are quite happy with the directions, part of the request that we made to our letter, so we are happy with the physical hearing.
Thank you. In-person, okay. Any other alternative view?
My Lord, my ladies, I like the approach you've adopted today.
Yes.
I think you may find that because the hearing is going to take a substantial period of time, some of the parties may want to have the option, especially when they are not scheduled to address the courts, to be present virtually. So I propose a hybrid hearing where the parties who will be addressing the courts can preferably be present physically, and those who, other parties who want to be present physically, but the parties also be given the option,
yes,
especially because the hearing will take a long period of time,
yes,
to occasionally appear virtually. So the way we have set up today, we set up that way for the main hearing. That's my proposal.
All right, thank you. Any other suggestion?
Yes, my Lord, I think we we should go to the way Kajama is suggesting. The only thing of that is that we should take care of the bandwidth, because you don't need to be a prophet to know that when that time comes, there will be very many people logging in on the virtual platform. And from the experience with the ECHO, there was a lot of trouble because of the traffic. So I think the administrative officers of the course should have that in mind.
Thank you for that suggestion. All right, I think that is sorted, and thank you very much. We have said that about the number of...
Can I ask a question to the council? How would you feel if some of the 7 judges decided to hear the matter virtually? Because of the same concerns.
And what do you mean that some of the judges will be sitting at home and others from...
Yes.
I think that we leave for the judges to determine on our part. I think we'll have no issue.
The only problem I say is that as I have seen or experienced, there are always respect for people. Can you hear? Can you hear? Whereas if we come from the school here, we can support this matter.
All right.
The only problem with that is when there's an issue, the judges would want to make a matter may arise in the middle of the proceedings, and if any number of judges are not in person, it can get pretty complicated. You need to consult. But when you sit in person, it's easier even within the court for quick consultations and after that.
Thank you, Senior Counsel.
This may be out of order, but there's a question of perception that may get out there if some of the judges are present physically and some of them are present virtually. Even the public interest in this matter, I would not be surprised if there's some citizens there who would think that the judges who are hearing virtually are not actually present and whatnot. I think it's a small sacrifice that we can make. In any event, I think how the court usually arrange, the judges are in a fairly well-isolated area from the rest of us. So I would suggest if it's possible, all the judges should be physically present, just because of the optics of administration of justice.
All right.
Yeah.
Sorry, just hold on. Just hold on.
Yeah, so the hybrid arrangement is not going to be new. We have already touched base with it, and what we normally do in such a situation is that we have an in-house arrangement for consultation. We at John go and consult with those who are around and those who are far. The situation that we find ourselves in, especially for those who are falling in the vulnerable age group, is of concern to all of us. And as you are aware, there is no hardware or a spare part for a human body. So we address the concerns of each and every person. We are open. Those who are willing to come and appear the way we have appeared, fine. And whoever will want and stay, I will stay. We use the same, the way we have been reaching out to some of the advocates who are appearing before us online.
All right. Thank you very much, my sister. Sorry?
My ladies and my lord, I'm not very old, but my very few years in practice has taught me that. Let's simulate the model that was used by the Judicial Service Commission when they were doing interviews there. And the fear that Dr. Musome Okulu is alluding to is not in the realm of conjecture. Assuming that a judge is appearing virtually from his or her house, How are we to know? I'm sorry to say, but I must say this, because we experienced this before the Judicial Service Commission whilst handling a matter for a judge. And all of a sudden, a commissioner was getting instructions from somebody else. So that that perception, we're not saying that this will happen, but perception is very important. For that reason, unless there is a reason why a judge ought not to appear physically, the public interest is in this matter be conducted in the public.
All right, thank you, Council, for all your views in that regard. I want to move to another area, possible hearing dates, so that we give comprehensive directions, and by the time we leave here, we are not going to impose dates that are very difficult for council and parties. Although we are going to conference and make the final decision on the number of days that we are going to allow the appellants to put in their submissions, their respondents, and their reply, you can see that if we are in the beginning of the month of June, it will take us to the earliest we can begin the proceedings. The earliest we can begin the proceedings is, say, around the 23rd of the month. So I would like to ask you to look at your respective diaries.
My Lord, if I may, very, very kindly, allow us to save the court's time so that we do not rehash the very long submissions about timing. And we've all said this case is very important. Once the court retires and decides how much time to give the parties, I think we can all trust the court to assign dates and be clear on that. Because if we start choosing dates now, we will be reaching the same arguments about how much time we need.
Thank you. Well, I was just going to give a time indication.
Thank you. Well, I was just going to give a time indication, not a specific date, to say that the hearing will have to be towards the end of the month and early July, so that within that time period, you do not crowd your diary. All right? That's the only indication I was going to give, so that we bear that in mind as we fix a date. Thank you, Mr. Kanjama. Lastly, there is an issue that was raised by Mr. Cheng Dudley. I don't want us to open this issue for much the discussion of the court to speak much on it. But I want us to conduct these proceedings with the dignity that is required. Let us be civil. Let us respect one another. Let us be balanced in our comments. Let us realize that we have an important judicial process that must be handled in a very sober manner, and let us not begin to, as it were, prosecute or defend our respective positions outside there in the media. Please allow the court to make a fair, properly informed decision without unnecessary attacks, comments by all concerned. I think that's all I want to say for now. And I think we will just hold on for a little while.
Kupata skiza tune hii Waibrania 13:8 dial star 811 star 963 hash.
Yesu Kristo ni yule yule jana, leo na hata milele. Wahibrania 13:8.
Ili kupata skiza tune hiyo ya Waibrania 13:8 dial star 811 star 963 hash, star 811 star 963 hash.
The greatest rally in the world is back in Kenya. Catch all the action of WRC Safari Rally live and exclusive on KBC Channel 1 from 24th to 27th